Hello, this is Vin Banj from Taylor Wessing. Welcome to our webinar today. Today's webinar is part of our regular webinar program where we bring you our expertise and views on topical data protection issues. Our regular attendees will be very familiar with our previous webinar topics, which have included looking at challenges such as connected data, online behavioral advertising, data security and breaches, and also more discrete areas such as data transfers and the finer points of transfer mechanisms, including the privacy shield. We've also looked at the GDPR before, in fact several times, in its constituent elements, and that's the topic that we will continue with today. Now, recordings of those previous webinars are still available if you missed them, and if you still wish to engage with us on those particular topics. In fact, we have some 30 plus webinars that are available to you, and they exist on our virtual data protection learning bank. So today, as I say, we're going to be continuing on the theme of the GDPR. So as you'll see from the slide on the screen, Taylor Wessing is a leading international law firm. We act for a range of leading clients in local and international markets, and we provide you with a full-service law firm offering. And we do so from our office footprint, which spans across Northern, Central and Eastern Europe, the Middle East and Asia, and also from our representative offices in the United States, both from the East and the West Coast. And together with our expertise on the ground, we provide you with our data protection offering as part of our full-service law firm offering. And our webinar today, like all our data protection webinars, is brought to you by Taylor Wessing's International Data Protection Practice. And this practice, this team, which is dedicated to data protection, advises on all aspects of data protection and information law. And we do so from the office footprint that I've just outlined for you. And if you're trying to get a better idea of the shape and size of this team, we are a global 22 partner-driven team. And we're also complemented by our international network of data privacy law specialists outside of Taylor Wessing's footprint, so we can provide you with a true global one-stop shop offering. So at Taylor Wessing, we have a dedicated microsite that's specifically for all things data protection, and that's our global data hub. From this site, you'll be able to access a news weekly update, where we cut through the privacy noise and focus on key data protection issues. And more recently, we've also created a functionality where we mail this out to you as well on a weekly basis. We also bring you topical issues, where we take a regular look at issues that are raising concerns or challenges or require more thought leadership around data protection challenges in this growing environment where data protection, data privacy is becoming more and more important in many parts of different businesses. You can also access webinars, events around the world, and also see where we are attending events and where we are speaking, as well as accessing the archive webinars that I referred to earlier on. Also, we feature our increasing number of country pages that will provide you for more deeper international coverage across the world as data privacy continues to grow across the world. In terms of today's webinar, I'm delighted to be joined by my colleagues Debbie Haywood and also Frederick Lenfar. My name is Vin Banj, as I said, and I head the data protection practice. I'm delighted that there will be three of us from our specialist team providing you with the content that we're going to deliver today and being your key presenters. Debbie is based with me here in London, and I'm delighted that Frederick can join us today. Frederick is our data privacy specialist associate based in our office in the Netherlands. And our profiles are there on the slide for you to access and see in your own time. Now, in terms of the agenda, I mentioned that today we're going to continue on the theme of the GDPR, but what exactly are we going to be covering? And you'll see from the agenda slide what we're going to be covering today. And it's three fundamental elements, we believe, of the GDPR, which you ought to be aware of, and we know many clients and contacts are saying to us that they'd like to know more about. So that's what we're going to be covering today. In a moment, Debbie's going to be taking a look at the core aspects of the data protection principles under the GDPR, and she'll be walking us through those elements. Then it'll be back to me when I look at this thorny topic of consent and why it remains an issue even under the GDPR. And then we're going to hand over to Frederick, who's going to be taking a look at the topic of privacy impact assessments and privacy by design and default in particular. So one of the key tools of compliance that is specifically mentioned in the GDPR. So Frederick's going to work through some of the issues that presents for us. Then in the usual way, we're going to be looking at polling questions towards the end. So we have a couple of polling questions that we'd love for you to click away and provide us with your views. And we will present the aggregate answers so you have an idea of what your fellow attendees on today's webinar are also feeling or have a view on in relation to those specific questions that relate to today's topic. As always, if you have questions that come to mind as we're going through the webinar, please use the functionality on the webinar to send your questions through, and we'll pick those up, time permitting, towards the end, around about the time we look at the polling questions, and we'll try and answer those for you on air in the webinar itself today. So to start us off by looking at the GDPR, in particular the core data protection principles, let me hand over to Debbie.
Thanks, Ben. Much as they do in the Data Protection Directive, or DPD, the data protection principles really form the heart of the GDPR, and they're key to understanding what drives the more detailed provisions in the legislation. Getting a handle on the ethics, if you like, of the legislation is absolutely key to understanding what you need to do to comply. Now, it's fair to say that the GDPR data protection principles are similar to those in the DPD, and they won't look unfamiliar, but there are subtle differences, and some concepts are more fully developed in the new legislation, with elements from the recitals in the Data Protection Directive often moving into the actual meat of the principles. Looking at the first principle, that deals with lawfulness, fairness, and transparency, and you'll see that on your slide. Personal data shall be processed lawfully, fairly, and in a transparent manner in relation to the data subject. So the GDPR requires that the data controller provide the data subject with information about his or her personal data processing in a concise, transparent, and intelligible manner, which is easily accessible, distinct from other undertakings between the controller and data subject, and which uses clear and plain language. In order to process personal data lawfully, you have to have a legal basis for doing so. Both under the Data Protection Act and the GDPR, there are prescribed sets of circumstances in which you can do this, including consent, which Vin is going to be looking at in more detail shortly. Another frequently used justification is that the processing is necessary for the purposes of the legitimate interests pursued by the controller or by a third party, except where those interests are overridden by the interests or fundamental rights and freedoms of the data subject, which require protection of personal data, in particular where the data subject is a child. Until recently, the equivalent provision in the DPD was heavily relied on by businesses to justify data processing, but recent case law from the Court of Justice of the European Union has made it clear that you cannot simply argue that you have satisfied the legitimate interest test because it's in your economic interest to process data. So care does need to be taken. This is not a catch-all to be used when there is no other justification available. Transparency is achieved by keeping the individual informed, and this should be done before data is collected and where any subsequent changes are made. It's important to remember that data is not always collected directly from individuals, but may be derived from other data sets, observed by tracking or inferred using algorithms. The GDPR has a mandatory list of the information which must be given to individuals where data is obtained directly from them, but also where it's obtained indirectly. How you let individuals know about what you're doing will depend both on the method of communication and on the target audience. Now, the UK's ICO recently updated its Code of Practice on Privacy Notices, Transparency and Control in order to assist with compliance under the GDPR. A traditional privacy policy on a website may fit the bill, but the more complex the use of the data and the smaller the medium on which information is delivered, the more creative you need to be. Delivering information in a way which can be understood by the target audience means using appropriate language and branding, but it can also involve techniques such as layering of information, directing users to a privacy dashboard, using pop-ups, tick boxes, and just-in-time notices or icons in order to highlight particular issues. These are needed not only to aid transparency, but also to give users genuine control and choice, which are essential to fair processing. Conversely, pages of small print, which the user will never read, are much less likely to qualify. The more unusual your use of data, or the more risk there is to the individual, the more you have to do to bring it to the user's attention. And in this respect, the issues are very similar to those under consumer law, so you're really looking at the level of understanding that you're allowing the data subject to have and whether that's appropriate to the type of processing that's being carried out. Moving on now to purpose limitation. This states that personal data shall be collected for specified, explicit and legitimate purposes and not further processed in a manner which is incompatible with those purposes. Processing personal data is only permissible if and to the extent that it's compliant with the original purpose for which the data was collected. Processing for another purpose later on requires further legal permission or consent, and the only exception to this requirement is where the other purpose is compatible with the original purpose. Indications for this will be any link with the original purpose, the context in which personal data has been collected, and the nature of the personal data, the possible consequences of the intended further processing for data subjects, or the existence of appropriate safeguards. It can be very tempting for organisations to collect as much data as they can and decide what to do with it later, or to collect it for one reason and then try to use it for another. Crafting the language around the explanation of your purpose for collecting data is going to be a fine art. The ICO cautions against simply providing a list of every conceivable purpose for which you might want to use data, but does also say that it is acceptable to use reasonably wide wording as long as it's still sufficiently precise to explain what's being done. And what is an incompatible purpose? If you collect data for the purpose of sending targeted music content, could you also send targeted film content? Arguably, and depending on the wording of your privacy notice, yes. Could you then use it to work out where people were when they listened to content? No, not unless you had included this as one of the purposes for using the data in the first place. Data minimization says that the purpose says that personal data shall be adequate, relevant, and limited to what is necessary in relation to the purpose for which the data are processed. Data controllers have to ensure that only personal data necessary for each specific purpose is processed, in terms of the amount of personal data collected, the extent of the processing, the period of storage, and accessibility. Under the GDPR, data have to be adequate, relevant, and limited to what's necessary in relation to the purposes for which they are processed, and this links back to the purpose limitation. Data controllers need to make sure that they collect enough data to achieve their purpose, but not more than they need. There's also an accuracy requirement, as there is under the current data protection law. Personal data has to be accurate and, where necessary, kept up to date. So this is a familiar concept. Inaccurate or outdated data should be deleted or amended, and data controllers are required to take every reasonable step to comply with this principle. There is a particular risk when relying on data obtained from another source, and you may need to take other reasonable steps to confirm accuracy. This could extend to checking underlying mathematical or statistical factors involved in generating profiles, which may result in inaccuracies and false assumptions. Another familiar concept is the one of storage limitation. Personal data shall be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data are processed. So once you don't need the data anymore for the purpose for which it was collected, you should delete it unless you have other grounds for retaining it. This means that you need a regular review process in place with methodical cleansing of databases. Personal data has to be processed in a manner which ensures appropriate security of the personal data, including protection against unauthorized or unlawful processing and against accidental loss, destruction or damage, using appropriate technical or organizational measures. Under the GDPR, like the DPD, personal data must be protected against unauthorized access using appropriate organizational and technical measures. This goes to the heart of protecting the privacy of individuals. Data controllers and processors need to assess risk, implement appropriate security for the data concerned, and crucially, check on a regular basis that it's up to date and working effectively. There are strict breach reporting provisions in the GDPR, as we've discussed in some detail in previous webinars and on our Global Data Hub. High-profile data breaches can cause significant embarrassment and expense for businesses. TalkTalk was recently fined a record £400,000 for failing to keep data secure, and this amount is going to look paltry once the new sanctions under the GDPR apply, under which fines for data breaches will be up to 2% of annual global turnover or €10 million, whichever is higher. The final principle is that of accountability, and this again is a really crucial element to grasp. The controller has to be responsible for and be able to demonstrate compliance with the GDPR. This means data controllers have to not only comply but be seen to comply. It's a short sentence, but it has major implications, and it's one of the notable changes under the GDPR compared with the DPD. It's a very much increased compliance burden, and much of that is sparked by the accountability principle. The range of processes that organisations have to put in place to demonstrate compliance will obviously vary depending on the complexity of the processing, but there are a number of things that they may include, such as assessing current practice and developing a proper data privacy governance structure, which may include appointing a data protection officer, creating a personal data inventory, implementing appropriate privacy notices, obtaining appropriate consent, and Ben's going to be talking more about that in a moment, using appropriate organisational and technical measures to ensure compliance with the principles, using privacy impact assessment, and creating a proper breach reporting mechanism. And I do recommend that if you missed it, you go to our website and listen to our webinar on key compliance points under the GDPR, because that deals with the detail of compliance and how you demonstrate that. I'm now going to hand you to Vin, who's going to talk about the complex issue of consent.
Thank you, Debbie. There is no doubt that consent is a core aspect of data protection law, and there's been much focus on consent as we've been approaching the finalisation of the GDPR. Even though consent has been a big focus point under the GDPR, let's not forget that consent is just one amongst several available legal grounds under which you can process personal data under the current DPDs and under the current directive, as it were. So at face value, obtaining an individual's consent in order to process their personal information may seem like an easy way to establish a legal basis for that processing. However, consent is not as straightforward a concept as it may first appear, particularly when it is not clear what conditions must be met for that person's consent to be really effective. So, this lack of clarity in the current law has, for many years in fact, led to a variety of different member states in Europe taking different approaches on their interpretation of what consent means, and also what consent looks like in actual practice and in reality, and the mechanisms used to obtain consent. And some jurisdictions have ended up taking a more stricter view than others as to what makes a person's consent to the processing of their data actually constitute valid consent. And if we were to look at other points of guidance, the Article 29 Working Party, the collective of data protection regulators, they produced an opinion back in 2011, and this opinion was very specifically on the definition of consent. And true to form, as an opinion issued by the Article 29 Working Party, it reached some 38 pages long, so quite a lot of text and reading involved in trying to understand the view of the collective regulators around the definition of consent. But it may give readers a better sense as to why consent is not the easy legal ground for personal data processing as it may otherwise first appear. Now, the revision of EU data protection law in the form of the GDPR presented the European legislators with an opportunity to put beyond doubt the meaning of consent, and also to ensure a more uniform and consistent approach across the EEA towards the interpretation of this really important concept. So, what is the revised approach to the concept of consent? And is the definition of consent any clearer? And will it be easier to work with when the GDPR applies automatically in the EU member states and across the EU member states and becomes fully enforceable from the 25th of May in 2018? And that's what I want to explore in the coming minutes on this webinar today. So on the slide in front of you, you'll see some wording around the definition of consent, which is found at Article 4 of the GDPR. And it may not initially appear to be a huge departure from what's found within the directive. And you'll see from the wording that appears on the screen in front of you now that consent of the data subject under the GDPR means any freely given, specific, informed and unambiguous indication of the data subject's wishes by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. So those areas of text appearing in bold reflect our emphasis to show where the new definition of consent under the GDPR really begins to expand and perhaps depart slightly from the old definition of consent under the current data protection directive. So let's just begin to break this down a little bit further in our analysis. So looking first at the specific points of difference in the directive, it is apparent that these changes do extend the requirements for consent. So unambiguous, for example, there must be an unambiguous indication of the data subject's wishes, which means in practice that the way the consent is collected should leave no room for doubt about the data subject's intentions in providing their agreement to their personal data being processed. Now, this may be relatively straightforward to achieve where the consent is being sought for a single processing activity or purpose, such as simply signing up to receive a newsletter. But consent will no doubt be much harder to demonstrate and achieve where the personal data collected is to be processed for multiple purposes and multiple uses. And arguably consent will fail if there is a lack of clarity against all of these multiple purposes. The next emphasis we draw out is the statement or clear affirmative action. And this ties into the second new element of the definition of consent around the components for proof, meaning that there needs to be a positive indication of agreement by the data subject to their personal data being processed. And that such an indication is not based, for example, on silence or pre-tick boxes or any form of inaction on the part of the data subject. Now, recitals are important to the GDPR, and here is a very useful example of why. Because you'll see the examples that are referred to at recital 32 in the GDPR, which include ticking a box when visiting a website, choosing technical settings for online services, or another statement or action which clearly indicates in that context the data subject's acceptance of the proposed processing of their data. There is also further detail found in various places within the article and the recitals to the GDPR. So unfortunately, it's not neatly contained in one particular place. Now, these examples provide supplementary meaning around those terms within the definition of consent, and this looks more familiar with the current consent definition under the directive. So, for example, freely given. The current guidance on interpreting freely given consent takes the approach that there should be a genuine choice on the part of the data subject when providing their data, and that they should not have been misled, intimidated, or negatively impacted by the otherwise withholding of that consent. And the GDPR seeks to formalise this view at Article 7, and also by way of explanation within a separate recital, so that consent will not be regarded as freely given where the following factors are evident. So it will not be regarded as freely given where the data subject has no genuine or free choice or is unable to refuse or withdraw easily and without detriment. And that reference is found at Article 7.3 and also at Recital 42. Same applies where the conditions of a contract, including those contracting for the provision of a service, are conditional on consenting to the processing of personal data that is not necessary for the performance of that contract. So when you're taking processing purposes beyond that which is the pure service provision itself, and that's Article 7.4 in particular. Another example is where there is a clear imbalance between the data subject and the data controller. And the example given at recital 43 is where the controller is actually a public body. However, it's worth noting that another relationship where an imbalance or elements of subordination can exist is a relationship between an employer and an employee, and that's recital 43. And also, separate consent cannot be given to different data processing operations, despite it being appropriate in the individual case. So where it should be appropriate that you provide or allow for that separate consent to be to be elected and to be selected and notified to you, but where actually you just don't make those different choices available. So really quite a few important aspects to be borne in mind when you're looking at whether or not consent and the different constituent elements of consent are actually going to constitute or amount to valid consent. The other elements that we've called out are the terms of specific and informed. So where we refer to specific, consent must be obtained in a manner that is distinguishable from other matters. It must also cover all processing activities that are carried out for the same purpose or purposes, and where the processing has multiple purposes, consent must be given for all of them, not just for a few of them, but actually for all of those purposes. And again, Article 7, in particular 7.2, and Recital 32 are the specific reference points in the GDPR for that. Consent must also be informed, and there are a number of references within the articles of the GDPR and the recitals that add some colour to this particular requirement. So looking at very specifically, the data subject should be aware at least of the identity of the data controller and the intended purposes of the processing, so recital 42. And then data subjects must be informed of their right to withdraw consent at any time prior to giving the consent, Article 7.3. And also to the specific information requirements found at Articles 12 to 14 of GDPR that set out that the information must be given to the data subject to ensure fair and transparent processing. So, as Debbie has also highlighted, and very closely linked to the concept of consent, transparency should not be left out of the equation where consent is concerned. There are other considerations that need to be kept close to the equation when we're looking at the validity of consent, both because the articles and the recitals include further requirements and interpretation that are relevant to consent. In particular, and we've called out a few of these points on the slide for you here, the controller must not simply obtain consent. He must also be able to demonstrate that the data subject has consented to the processing of his data, meaning that records will need to be kept for the consent to be verifiable. So it's important to be able to show that the consent is verifiable. So it's almost a concept of audit trail to be able to demonstrate that you can verify the consent was indicated and granted. Requests for consent in the context of a written declaration must be presented in an intelligible and easily accessible form, using clear and plain language, and in the latter case of plain language, not including any unfair terms. So the concept of balance begins to creep in more and more in this particular point here. Now, requests for consent made by the data controller using electronic means must again be clear, concise, and not necessarily disruptive to the use of the service which it is collected. So again, a sense of clarity needs to be built into that whole process around consent. And the data subject must be able to withdraw his or her consent at any time. And the process for withdrawing that consent must be as easy as that process for which they give consent. So you can't deliberately or otherwise create a mechanism that makes it harder to withdraw consent or not consent, whereas otherwise you're providing a more easy, because it's convenient to the data controller, mechanism for giving that consent in the first place. So these last 2 points in particular show that efforts to disrupt, to confuse, or to otherwise hinder the consent process will create consent validity challenges. And I think that is just the fact that we have to accept under the GDPR when we are looking at this balance of whether or not consent is valid. And the specific requirements for consent can also vary depending on the context of the specific processing. And one example in the context of processing of data of children is where, depending on the age of a child and the nature of the process and the consent of the holder of the parental responsibility may also be required. In other cases, consent approaches may still vary across member states, where the GDPR allows for the different approaches to be taken across different countries or member states across Europe. Again, looking at the example of children, this includes the option for member states to lower age thresholds for children, below which parental consent processing would be needed, thereby retaining some of that divergent approaches to consent across the EEA, obviously depending on the circumstances. So this is one key area in particular where the GDPR actually is as clear as it can be, showing that there will be a lack of harmonisation if the member states elect to use their ability that the GDPR gives them to adopt their own approach towards consent in relation to the age of a child, and therefore the equation that applies and the pitfalls of having a lack of valid consent if you try to apply one standard that is different when you go across to another member state. I now want to just look at consent, and in particular the context of explicit consent, and that's probably the final point I want to try and cover in today's webinar from the perspective of looking at consent. I think it's important to bear in mind that when you're considering the legal definition of consent, is that there remains a distinction in the GDPR between the definition of consent and the separate references in the GDPR to explicit consent. The need for explicit consent is referred to separately in a number of places within the GDPR. And examples can be seen in the context of processing special categories of data, which under the current directive are referred to, and also implementing laws under the current directive, are often referred to as sensitive personal data or categories of sensitive personal data, like health and so on. Or in the explicit consent-based derogation for the transfers of data subjects data to third countries. Now, despite these specific references, the need for explicit consent, this term is not separately defined from consent in the GDPR, and the difference between the two terms is, therefore, sadly unclear. Now, while some aspects of obtaining consent in the GDPR is helpfully outlined, I have to say that in conclusion, consent is not an easy option to satisfy because there are so many aspects to consider, and failing on any one of those elements can cast sufficient uncertainty on the validity of consent. So for the reasons I've outlined and walked through with you today, consent is actually quite far removed from being an easy option under the GDPR, and therefore quite far removed from being that sort of silver bullet in terms of being able to say we have valid grounds for processing data across all the many different purpose categories we may have. Now, greater specification around what is meant by consent has brought with it more detailed and therefore onerous obligations. And I would suggest that data controllers should first look closely at the other legal grounds that are available to establish whether there is a preferable alternative to the consent path. And given the extensive lengths that a data controller now has to go to demonstrate valid consent, it is really difficult to see what further steps may need to be may be needed in order to distinguish consent from one that needs to be more explicit consent as well. And for this and other reasons, I think the arguments around what makes consent effective and unlikely are really not going to be put to bed by the GDPR and the black and white wording of the GDPR itself. And it remains still, I think, a very rough-edged concept to tackle. And we all do really wait with anticipation as to what guidance from either DPAs or further guidance under the GDPR might actually provide in terms of how different and the many different elements of the path towards consent can really be met in a practical context. That's all I wanted to really say on consent, is really to outline those different points that we've mentioned today. I'm very certain we're going to be visiting this and other thorny issues under the GDPR again. But for now, I'm going to hand over to Frederick, who's going to take a look at privacy by design and by default. Frederick.
Thank you, Vin. The concepts of privacy by design and privacy by default are generally seen as fundamental components promoting compliance with data protection laws and regulations from the earliest stages of initiatives involving personal data. Originally introduced by the Canadian Privacy Commissioner of Ontario back in the 1990s, the concepts of privacy by design and privacy by default have in recent years seen adoption by regulators from around the world as essential components of privacy protection. The Canadian Privacy Commissioner has formulated 7 foundational principles that resonate even now in, among others, the GDPR. Summarized as follows, these 7 principles give a good understanding of the concept of privacy by design. A privacy by design approach should be proactive, not reactive, and should be preventative, not remedial. Privacy invasive events need to be anticipated before they happen. Privacy should furthermore be the default setting and should be embedded into design and architecture of IT systems and business practices. Legitimate interests like privacy versus security should be accommodated in a positive-sum, win-win manner. It should not be one or the other, but both. Privacy by design, furthermore, needs to ensure a full lifecycle protection in order to ensure that all data are securely retained and then securely destroyed at the end of their lifetime in a timely fashion. Any practices and technologies need to operate in a visible and transparent way according to the stated promises and objectives and subject to independent verification. And last, but certainly not least, privacy by design requires architects, designers, and operators to keep the interests of the user central. In choosing to include privacy by design and privacy by default as key principles in the GDPR, the European legislator has acknowledged that privacy is not something that can be ensured only by means of legislation, but that it should be a fundamental component in the design and maintenance of information systems and a mode of operation for each organization. Though newly introduced in the GDPR, the adoption and enforcement of privacy by design is already actively pursued by national regulators. A practical example of this will be given later on in this presentation. Article 25 of the GDPR codifies both the concepts of privacy by design and privacy by default. Under this article, it is the data controller that is required to implement appropriate technical and organizational measures designed to implement data protection principles such as data minimization. An obligation to implement appropriate technical and organizational measures in order to ensure data is processed in a lawful way is on itself not something new. Under the current EU Data Protection Directive, data controllers are required to implement technical and organizational measures to protect data against unlawful processing. This is, however, merely an afterthought, as it only relates to data which has already been processed. What is new under the GDPR is the obligation to implement such measures from the earliest design process, both at the time of determination of means and the processing of personal data itself. Instead of being a mere afterthought, data controllers are required to include data privacy in every aspect of product or service design. The GDPR takes a rather flexible approach to privacy by design. This means that in implementing privacy by design, a data controller needs to take into account the state of the art, cost of implementation, and the nature, scope, context, and purposes of processing, as well as the likelihood and severity of risks to the rights and freedoms of natural persons posed by the processing of the personal data. To give a practical example of privacy by design, here in the Netherlands, utilities are required by law to provide every customer with remotely readable smart metering systems by 2020 at the latest. Though a nationwide switch from analog meters to smart meters is set to result in benefits in terms of, among others, a lower energy consumption, it does come with certain privacy risks, especially since smart metering systems can in principle be read by utilities at basically any given time for any given purpose and without cause. By regularly reading energy consumption through one specific smart meter, one can assess when an individual is at home, or for example on holiday, or how big a specific family is. One may even be able to assess whether a client is employed or not by just checking whether energy is used during office hours. All information that can potentially be abused or lead to wrong assumptions. For certain people, it may, for example, be interesting to know at what specific times a house is empty. One assumed employment status may furthermore be interesting for the assessment of accounts receivable risks. Privacy by design principles require data controllers to take into account any such privacy risks. In this particular example, utilities are under the GDPR required to design smart metering systems, infrastructure, and internal and external policies and permissions in such a way that there is a minimal risk of misuse of information. In addition to adhering to privacy by design principles, the data controller will need to ensure that by default only personal data that is necessary for a specific purpose of the processing of data is processed. In particular, such measures need to ensure personal data is not automatically made available to third parties without the individual's intervention. By way of a practical example, when creating an online social media profile, privacy settings should, under the GDPR, by default be set on the most user privacy-friendly setting. Setting up profiles to be public by default is no longer allowed under the GDPR. Though potentially putting more strain on the conception and development of new initiatives, following privacy by design principles can be used as a means to help ensure full compliance with data protection principles as required by law. It can lead to potential privacy issues being identified at an earlier and less costly stage, and to the increase of awareness of privacy and data protection related matters throughout the entire organization. Though the envisaged flexible approach gives data controllers the ability to determine their level of compliance based on the privacy risks involved, it also gives rise to uncertainty as to the required level of compliance. This takes on a degree of urgency, given the statutory fines of up to 10 million euros or up to 2% of annual worldwide turnover, whichever is higher. In this light, it is therefore important for companies to regularly assess privacy compliance by, for example, conducting regular privacy impact assessments. Privacy impact assessments are an integral part of taking a privacy by design approach and can be used to identify and reduce the privacy risks of any project. Not only may it reduce the risks of any misuse of personal data, it may also help in designing more efficient and effective processes for handling personal data. The UK Information Commissioner's Office has issued a privacy impact assessment code of practice, outlining the principles which form the basis for a PIA and given practical guidelines for identifying and minimizing privacy risks created by new projects or policies. The ICO Code of Practice has been endorsed already by many other regulators, among others the Dutch Data Protection Authority. Integrating these principles into a privacy by design approach may significantly reduce the organizational strain associated with privacy by design and may, as said, create more internal awareness. As pointed out earlier, although the concept of privacy by design is not present in the current Data Protection Directive, national regulators are already actively pursuing its adoption and enforcement. The Dutch DPA, for example, recently imposed an order subject to a penalty on the company BlueTrace, a company supplying Wi-Fi tracking technology in order to track mobile devices in and around stores. The BlueTrace technology collected and stored personal data, including the MAC address of each mobile device within its Wi-Fi range, but in doing this was not able to make a distinction between customer mobile devices situated inside a particular store and mobile devices of passers-by outside a store. Therefore, the MAC address of every mobile device in reach, regardless of whether or not it was used by a store customer, was in principle stored for an indefinite period of time and without informing the data subject. According to the Dutch DPA, BlueTrace was in breach of a number of data protection principles, including data minimization, data retention, and of its information obligations towards data subjects. Adhering to concepts of privacy by design from the outset in this case would likely have resulted in BlueTrace identifying risks at a much earlier stage and less costly stage in the development of technology. It would therefore probably have avoided any DPA enforcement. And then you can go on to the next slide, I think.
Thank you very much for that, Frederick. And as I mentioned at the beginning of the webinar, we do want to just poll a few questions with you in the usual way, and we'll do that next. And then also, whilst we're waiting for the answers to come through, there's, as I hoped and expected, quite a few questions coming in. So we're going to look at some of those questions within the time that we have remaining as well. So the questions should appear as if by magic on the mechanism in front of you. So you should be able to indicate to you. So the two questions really. One on the topic of consent. What we're trying to gauge here is whether you plan to continue to take an increased focus on consent and look to upgrade consent in particular to meet the heavier requirements under the GDPR. So whether you're going to increase that focus on consent and how it will work and what its validity will be. So yes, if you plan to take a much closer look and try and evolve that towards the upgraded requirements under the GDPR. No, if that's not something you're going to you plan to do, or C, is if you're just going to hold fire for a moment. You're going to wait to see what further guidance may bring. So let us know what your thoughts are, if you have any, on the issue of consent and what you plan to do from that perspective. The second question is really looking at the issue and the topic that Frederick was covering. So around privacy impact assessments and privacy by design. Again, just to help your fellow attendees appreciate where you are on this topic. So do you currently use privacy impact assessments or a form of privacy by design? So A, yes, but it's an informal or light touch documentation approach. B, if the answer is no, it's just not something you do at the moment. Or C, if it's something you plan to upgrade to in terms of a more comprehensive process before the end of 2017. Again, just to give your fellow attendees an idea of what you're planning to do and when you might expect to do that. So some of the questions I can see you've been clicking away. Excellent, we've got the results through. So looking at the topic of consent, a huge chunk of you, so almost 57% of you, say yes, you will be taking that closer look at consent and what it means under the more onerous requirements under the GDPR. And then a small majority have said no, but the really bigger remainder, almost 30% of the remainder, say you will wait for guidance before you actually take that point any further. So on the topic of privacy impact assessments, I know a few of you are just still clicking away and the machinery is just coming through with the answer. The question here is if you're using privacy impact, what is the basis for that at the moment? Is it A, yes, but it's an informal light touch documentation approach? And the answer that you're given here is over 30% of you, over 32% of you have said yes, you do use TIAs and privacy by design already, but it's a fairly informal light touch approach. Only 20% of you say no, this is something you don't use at all, but a huge 47, 48% of it's just some of you still clicking away. So you plan to upgrade that to a more comprehensive process before the end of 2017. So I hope that's just enlightened you on what some of your fellow attendees and the companies that we have on the webinar today think in relation to the topics of consent and preparation for consent in the GDPR, and also preparation towards the topic of TIAs and privacy by design as we roll on towards 2017. So we have just a couple of minutes left, and we have had quite a few questions in, so let me try and pick out the questions as we go through in order, and I will try and answer as many as I can within the allotted time. So the first question is it a fair statement that if informed consent is obtained, data can be processed in any way? In other words, stored outside the EEA, sold, or whatever processing you want if the informed consent is obtained. So I think the best way of looking at this point is if you're trying to say, if we have been clear enough and we've informed the data subject of all the different categories of processing that may take place, then can one form of consent be clear enough for all of them? Now, there is nothing under the GDPR that is as prescribed as, for example, the approach under the Korean privacy law, which does point more towards having very clear, verifiable consent against each individual purpose. And the GDPR does not go to that extent, but the GDPR does make quite clear that you need to be setting out all those different purposes and doing so in a greater degree of clarity that takes place at the moment. Otherwise, consent against multiple purposes is going to be very, very difficult to demonstrate as being valid consent. Another question here is, can you please define personal data in the context of the GDPR? And this one's relatively straightforward because I've prepared and have a copy of the GDPR in front of me. So Article 4.1 is the page on definitions. And personal data, and I will read this out, means any information relating to an identifiable or identifiable natural person, in other words, data subject. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an identification number, location data, an online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. So I think it's fair to say, without even delving deep into each of the constituent elements of what I've just read out, the definition of personal data under the GDPR is broader, and it is wider than the context under the GDPR. And I think it was designed that way. And if you to read back and you maybe even look at some of the content that we've published over the last 3 or 4 years, where we've looked at how the GDPR may change in the context of the definition of personal data, we always knew it was heading towards a broader definition, particularly if you look at aspects of not only the more direct identifiers, but the indirect identifiers around personal data as well. So another question here is implied consent gone for sure? Well, I certainly think it's really hard, it's really difficult to see how informed consent can really help you meet the various elements of valid consent. It's really difficult to see how that's going to work. Given those constituent elements that I walked through when I talked about consent, and also given the different nature of how those requirements just need more to be demonstrated in terms of not only the understanding that the data subject has to have around the purposes, but also the way in which that is communicated, the way in which you receive that indication. And I think it's going to be very, very difficult for implied consent to work under the GDPR. Another question here is, if an employer or employee consent is not possible, how might an employer process data? And I assume them in processing data in the context of that employment relationship. Well, I think if there's one thing that we can stress here, that what consent does is consent requires a data controller to be very clear on the constituent elements of processing, and being very clear on those constituent elements of processing and purposes that are fundamental to the relationship, and those which are perhaps better defined as secondary or tertiary purposes. In other words, those which are not core to the relationship, not core to the relationship between the data controller and the data subject. Now, in an employment context, that is going to mean that the vast majority of data processing purposes, which are fundamental, which are necessary, which are very important towards making that employment relationship work, as long as they are spelt out very clearly, as long as they're explained very clearly, then consent ought to be possible. But if you're going beyond that and you are using data for different purposes, or purposes that are not necessary or not core to the employment relationship, then I think it's right that there will be an element of doubt, and in many cases huge doubt, on whether those secondary and tertiary purposes can be provided for in terms of valid consent, and more importantly, whether or not a data subject is given the option not to consent or withdraw their consent against those non-core employment relationship purposes. There's another question here. I know we're coming up to our allotted hour, but I'm keen to try and answer as many questions as we can, so I will still continue just for another moment or two. Another question here is, does the need for clear affirmative action mean that companies will no longer be able to rely on a soft opt-in for existing customers? And I think this partially calls on the answer that I've given to one of the earlier questions around passive. And therefore, I think a passive nature towards consent and a passive nature towards communicating consent is just not really going to be enough under the GDPR. And again, for all those purposes that I outlined, it's going to be very, very difficult to be able to demonstrate that passive consent or soft opt-in from that perspective is enough to signify in that verifiable way that the data subject consents. And there will be an inherent vulnerability, I think, if you proceed on that basis, for a data subject to say, well, actually, I just didn't. And you have no means of otherwise saying that you had that verifiable affirmative consent against those clear data processing purposes. So soft opt-in, again, I think is going to be very, very challenging because of the very passive nature of it. I think, though, there ought to be some distinguishing grounds, because if you are, for example, simply allowing a data subject to sign up to receive a newsletter where it is absolutely patently obvious that by providing an email address that they will be signing up to receive a newsletter, for example, and if that is the only purpose that we're talking about, then perhaps there is more grounds and there is more hope for that passive nature of consent and not requiring further stronger mechanism for that received indication. That ought to work in that very simple sign-up sort of process. Another question is, what weight do you think will or should be given to the legal effect of the recitals in the GDPR, especially where they are dealing in more detail with consent than perhaps any of the existing words and text that we see in Article 4? I think recitals are going to be very much more than merely side notes in this piece of law. Regulators have already been saying, and we know certainly in the UK, the ICO has said that, when they look to interpret what is required under the articles, they look side by side at the different recitals that are very relevant to that article. So they will read it as part of the law. They will read it as an important part of interpreting what is meant under the articles. And it's hard to see why the courts also would ignore context that is provided within the recitals, in the same way, certainly within the UK, that courts will always look towards the preamble text in legislation to see if there is any guidance or is there any interpretation towards the meaning of the actual operative part of the legislation itself. So I certainly think the recitals are not there to be ignored. I think they are going to form an important and an integral and core part of interpreting the GDPR and the main articles itself. The final question I'm going to take, again conscious that we've run out of time, is if explicit consent is required under the GDPR for any third country transfer, what are the implications where cloud storage is employed for data flows when the actual location of the data center may not be known by the data controller? So quite a few elements coming into play here. One is consent in relation to transfer to a third country, and consent in relation to not being able to be fully transparent on the extent of the data processing, because you can't necessarily be clear as to which countries will constitute third countries, particularly in that more nebulous cloud storage type of offering that might be used. I think from my perspective, consent is one ground, but not the only one. And I think that's how data controllers should look at some of the more thornier areas under the GDPR and some of the more difficult areas of data processing activity where it's just not going to be possible to be reliably moving forward on the basis of consent alone. And remember, consent is not the only option for validating and legitimizing a transfer to a third country. Transparency is absolutely important, and it might be that transparency means that you're explaining that there is this flexible nature of which third country is important here. So transparency will still have a role to play, but I think consent is going to be difficult. So you will need to look at other solutions and being clear on what those other solutions are, whether that's the privacy shield, whether that's the standard contractual model clauses, whether you have binding corporate rules, or whether the storage provider has, for example, processor BCRs in place, or whether there is another form of adequacy finding that can be used as the prime route for legitimizing the data export and not relying on consent for that prime route. So I know there's a couple of questions we haven't quite got to, but we are quite a bit over time, so we're going to call it a day there. So please do take a look out for our ongoing program of events, which we're going to be announcing soon. And if you've already signed up to receive those alerts from us, we will let you know when our webinar program commences in 2017, what sort of topics we're going to be looking at, and also how you can be informed about our forthcoming events beyond the webinar program, such as our annual privacy conference, which will be taking place in February in London, and also the quarterly breakfast events that we run in London, as well as the other events that we run across the Taylor Wessing footprint. And we really hope you can join us for all those events. So look out for those either on the Global Data Hub, or do sign up and we'll automatically send those alerts out to you. But for now, from me, from Debbie, from Frederick, and the entire team here at Taylor Wessing, thank you very much for joining us today, and goodbye.